am thrilled to be here with our co-hosts, one of our three co-hosts, Danya Perry, who's my colleague in law and in podcasting. Unfortunately, Kathleen Rice, a former member of Congress, former Nassau County, New York District Attorney. She is away, and so she couldn't join us, but we didn't want to miss this momentous Supreme Court decision and the opportunity to discuss it and how it applies to all of the pending cases against Donald Trump, but also how it's most specifically, and what I'm interested in talking to you about, Danya, is how it's going to apply to the Manhattan DA case, the Manhattan DA's office, where I worked for 30 years, and you represented Michael Cohen in this exact case. So this is a trial that was near and dear to both of us. And I think we should really talk about what we think, since you were in court a lot of it, and I followed it very, very closely, obviously. We should talk about how this immunity decision is going to impact it. To just today, as we are recording, the case has been put over. It was supposed to be sentenced July 11th, and it's been put over now to September. So we have a lot to talk about on this episode of MissTrial. It's a huge, probably the biggest case in our lifetime, this immunity decision, that and Dobbs, frankly, overruling Roe versus Wade. I would say those are probably the two biggest Supreme Court cases in our lifetime. And so as practicing lawyers and former prosecutors, I think there's nobody I'd rather talk about it with than you, Danya, and have this conversation. Let's just dive right in and talk about this incredible decision that came down, essentially making the president king. I mean, that's what the dissent is saying, right? Granting sweeping immunity to to former presidents. And I find the ruling absolutely shocking. It went further than I could have ever imagined, actually. And I've read it, and I still can't believe how surprising it is that they did what they did. I don't even know how you want to begin, because there's so much to talk about.
Yeah, let's begin with the broad view, and then we can zoom in. I agree with you, Karen. When I first read it, and I just read the top line, and at first I thought, well, this isn't shocking. This is, both parties essentially agreed that unofficial acts or personal acts would not receive immunity, and that's what the Supreme Court said. In the government, effectively conceded that there was, some immunity might be in order for official duties. But what really is kind of breathtaking is the middle area, which the court said that for acts that are on the outer perimeters of the president's official duties, those receive presumptive immunity. So any actions taken within the president's constitutional authority, that receives absolute authority. Anything that's purely private or unofficial, that does not get immunity. But it's this broad, vast space in between those, where actions that are taken that are outside the core functions, but still, potentially within the president's official duties, that receives a presumption of immunity. And that effectively, if you read the opinion, and you don't even really have to read between the lines, you see that is going to be effectively immunized conduct. And that's where it seems like that's where all the action is, certainly in Jack Smith's indictment against Trump, and perhaps in this former president's second term if he's reelected. And so I agree with you. It's sweeping, it's broad. Chief Justice Roberts, in his majority opinion, tried to act like it really wasn't, and that they weren't giving Trump exactly what he wanted. But as Justice Sotomayor said in her dissent, that's kind of some gaslighting there. It is, she says, even broader than what Trump had wanted. And so I think, where the next phase is going to go with respect to this case, it's going back to the district court. District Court Judge Tanya Chutkan is going to have to determine, because these justices gave her very little in the way of guidelines, she's going to have to determine what is and what is not official conduct. And then, so that's the narrow Trump case. And then more broadly, we're in kind of constitutional nowhere land. And what this means for our constitutional democracy is going to be an open question and a very scary one, again, if there's a second term. But we can break down, the various aspects of the ruling or talk about next steps. Where do you want to go? Because as you say, there's so much to talk about and it's hard to know how to fit it all in.
Well, let's talk about the ruling a little bit because, not everyone will know what are core responsibilities of the president that is within his job description. A, B, what is a presumption, right, under the law? What does that mean, and how do you rebut a presumption? And I ask those two questions because I've been having this debate with people. Let's just be obvious, right? The president, one of his core responsibilities or core job functions is to give out pardons, right? Mm-hmm. Or to, he's the commander in chief of the armed forces, right? Those are two examples that are squarely presidential functions. And but my question is, when is it ever, okay, so fine, pardons, but let's say he were to sell pardons or give a pardon in exchange for a bribe. How is that part of his job? In other words, isn't his job to also take care of the laws and the take care clause of the Constitution, right? He has to take care of the laws, that are faithfully executed. And that's part of his job, right? Like that's a core function that he has to do. We all have to follow the laws. What they're saying here is, I can't think of another person in their job that gets absolute immunity from committing a crime. Nobody, right? There's no judge. There's no member of Congress. There's no, this gives him license to commit crimes. And that to me is, okay, yes, giving out pardons, should you have given it to this person or that person? That shouldn't be untouched, right? That is your job to make that determination. But if you then break the law and commit a crime, I don't see how that's ever in a presidential job description. So that just was one of the shocking things. Even if you were to, this outer perimeter official conduct test comes from and borrows from the civil world, where in several cases, I can't remember if it's Fitzgerald v. Nixon or Nixon v. the United States, but in one of the Nixon cases and in Clinton v. Jones, the United States Supreme Court talked about civil liability and when a president can be sued. And that's where they got to that's where you get to the core job functions and outer perimeter test. And the Supreme Court chastises the special counsel and Judge Chutkan, as well as the DC Circuit, for not making this determination of what's core job functions and what's not. And several people have said to me, shame on Jack Smith. He was rushing this. Why didn't he, develop that? And why didn't Judge Chutkan do that? They were just rush. And I said, no, because that shouldn't be the test. To me, it's, you broke the law. That's the issue. It's not, it was a core function or not a core function, because I don't see how that's ever part of the job. Anyway, that's why that piece of it just is a head scratcher for me.
I agree. That's the most shocking part of it, because there are obviously some core powers that are laid out in Article 2 of the Constitution. But as you point out, and as the dissent pointed out, you could certainly imagine scenarios where someone is selling pardons. What would prevent Trump in a second term from selling pardons for $1 million on Truth Social? What would prevent him? The famous SEAL Team 6 example, right, that was discussed at oral argument. What if Trump used the military to go and take down a political rival? Those are clearly, use of the military and his pardon functions are clearly within his constitutional powers. But this court doesn't mind, what the motivations are. They won't allow a prosecutor or jury to look at whether something within the core functions was done for criminal purposes, for, out of revenge, for purely personal reasons, corrupt reasons. It does not matter. The president can do that. So in that sense, one man is king. One man is above the law. And, former President Nixon would have been fine ordering people to break into Watergate and violate the law every which way. This decision came, several generations too late to help him, but he would have been just fine and could have stayed in office and wouldn't have had to resign because he could not have been prosecuted for doing all that. And to your point, Karen, the Nixon versus Fitzgerald case, which established limits for civil liability, now the president's civil liability will be broader than his criminal liability. There's a balancing test in the Nixon case that is not. It just doesn't apply here. So a president can act with impunity. He can do what he wants now, and he can feel pretty confident that he's going to skate away with it. And so that is a pretty frightening specter.
And the Supreme Court did this as a separation of powers decision. I think that might have been the first sentence. This is separation of powers. The president alone has Article 2. He's the only. I think it was in the Vance case when Cy Vance went up to the Supreme Court, where they said it's the president alone who makes up an entire article of the Constitution, entire branch of government, and so they said because of that he is afforded special treatment, and they want to have a vigorous and energetic president who is not looking over their shoulder when making decisions. They think they're going to open up some floodgates. Well, for over 200 years, there's been no floodgates. This is the first time a president's ever had to be prosecuted. It's the first time we've ever had someone to do the things Trump did. And it was interesting to me how they kind of almost made excuses for him in this decision by trying to create these rules, right? Like, it's funny when they overruled Roe versus Wade, the reason they gave was they said, basically the Supreme Court here made up the rule, first trimester, second trimester, third trimester. They just made all that up. It wasn't legislated, right? They kind of did the same thing here. They made this up, right? There's nowhere that the Constitution doesn't talk about this. There's no law that says any of the tests that they put in there. They literally just made this up to suit their purposes. That's how I view it.
Doing this all season, all Supreme Court season, right? They threw out Chevron deference and said administrative agencies basically don't get to weigh in on the interpretation of regulations. And that was made up too. So, stare decisis, which is respect for the law as it has been thrown out the window with this Supreme Court. And so, they made it up. But what, really is particularly galling is, and again, I go back to what Justice Sotomayor pointed out, is how they try to pretend like they're not making new law when they're just brazenly doing exactly that. And we're about to see how this plays out in the real world and in this actual indictment. It was easy for them to say what has to come out of the indictment, right? There's certain actions that are alleged that they have said that is within the president's core function, his dealings with Justice Department officials. Others, Chief Justice Roberts said, was trickier and was presumptively immunized, but
what's
that?
Talk about what's a presumption in the law?
Yeah, it's a heavy thumb on the scales, right? It's what it is in real life too, right? This is all things being equal. We're going to say this is immunized. The government is going to have to, the burden, of course, in any criminal case is on the government to prove every element of every alleged crime beyond a reasonable doubt. That never shifts. But on this issue, the court must presume that certain duties are immunized, that the government cannot, we'll talk about this, but cannot even use as evidence this conduct, much less charge it. And the government is, in a pretrial setting, going to have to prove to the court that, in fact, no, this was not within the penumbra or the perimeter of the presidential authority. So that's what it is. It's just, all things being equal, the court would have to find that certain conduct was immunized.
Yeah. And so that was also, again, I totally agree with you. I thought that was really surprising, that piece of it, right? That this presumption piece. The other thing that I think the thing that surprised me the most is how it applies to evidence, right?
Yeah. That I agree. That's what I was just trying to put a pin in, but let's talk about it right now, because it's crazy. I don't know anything else that's quite like this. Here, the court said they didn't just limit what can be charged and what allegations the government can ask a grand jury to look at, but the government cannot admit testimony or, as the court said, private records of the president or his advisors to probe the official act itself. So what the court is saying there is this stuff can't even come in as evidence of the charges that are allowed to skate through.
How are you about the presumption? How are you supposed to prove that this was, in other words, right? Like, what if that's where the evidence is of the fact that that this was not part of his core responsibility or job description? What if it's in this evidence, if you will? How are you supposed to prove about the presumption if you can't even look at that evidence?
I'm not clear whether the court can look at it in a pretrial setting to make that determination. It's a great question. I'd really have to comb the decision itself, and then,
because how would a prosecutor even get it? Right? I think they would assert immunity and
over the records. Yeah, I mean, they could get it from a witness, although, yeah, certainly it now seems a witness could assert privilege over that. A court might look at it in camera and decide, but it is clear, at least from this opinion, that certainly it cannot go in front of a jury, and that's just, to me, that's bonkers. I don't, it's that is more than anything else, because look, it is clear enough, particularly based, I mean, the court said it right in the majority opinion, that it's clear that some of these allegations are going to go forward. There's agreement on that, even from the parties. So that something can and should proceed, but how will the government prove that up if it is not allowed to reference anything that the court determines is, within the president's official duties? It will really cabin the government's case.
Yeah. Totally. It's like they created both an immunity and a privilege, because now there's this.
Yeah. So that, to me, is what is going to hamstring this case and Jack Smith's ability to put it in front of a jury and prove his case beyond a reasonable doubt. So much of this is going to have to not just come out of the indictment, not just out of the charges, but out of the purview of the jury. Right. And it's not clear to me, of course, how stripped down the evidence is now going to be, and whether or not there is a viable case to go forward. It seems there is, but of course we don't know the totality of what the government has to put forward to the jury.
I mean, what the decision did was it both spelled out the things that they said are clearly out, right? So anything involving the Department of Justice, when Donald Trump asked the Department of Justice to investigate these claims of election fraud, after he had lost the election and before the inauguration, when he tried to replace acting Attorney General Rich Donahue with Jeffrey Clark, who was not qualified, but was willing to basically make up these false claims of election fraud. They're saying none of that can come in. All of that entire kind of weaponizing the DOJ piece of this is out, that's purely in the purview of the president's core duties. He can basically essentially do what he wants with the DOJ, use them for good, use them for bad. He's immune. The next thing that they said was everything else, you have to have a hearing. Essentially, you have to have a hearing to determine whether all of the other conduct falls within the president's job description or not. They went on to say that they think that, for example, the pressure campaign on Mike Pence, that could be immune, depending. So they kind of said what to look at in order to determine that. And they said, develop more facts, but we think this might apply and this might apply, and develop more facts here. I mean, essentially sent it down for an evidentiary hearing that you predicted on MissTrial and said this is how the American people could actually see the evidence. I mean, ever since you said that, Danya, it was such a, like, somehow you knew this was going to be the case. It's like you were prescient completely, but really you're just experienced and you really know kind of how these things go. But you are 100% right. They are sending it down for a hearing to develop all of these facts in order to apply this new made up law. And frankly, so ever since you said that, I've been thinking about how would this work? And it's such a brilliant idea. I hope what they do is I hope they just try their case, literally,
Yeah.
put the whole trial on and let them decide, in, out. And then honestly, the American people then gets to see all of the evidence, whether there's an ultimate, whether there's an ultimate verdict, that won't happen at this hearing, but you'll basically have a trial. And so I think that's what's going to come next based on this. The other thing they dropped in a footnote, I don't know if you noticed this, was, and Judge Chutkin, we also want you to hold a hearing to determine whether 2 of the 4 counts, the 18 United States Code 1512C, the obstruction of official proceeding, whether those charges still stand based on our a few days ago ruling in Fisher, where we held that you have to obstruct with like a document or a piece of paper.
Yeah. That piece of it seems to me, should be okay. Because of the allegations in the indictment are that Trump, was part of this conspiracy to submit a false slate of electors, and that would fall within the now narrowed rubric that the Supreme Court has said that obstruction law covers. So I think that's okay. But yes, and look, they've invited her to hold an evidentiary hearing now. And look, it wasn't particularly prescient. As you say, I've seen it. The world saw it. The country saw it in the Georgia fake, the election fraud case, where that judge held an evidentiary hearing when Mark Meadows and a co-defendant argued that their conduct, their actions were immunized, essentially, that they were official acts. And he held a full-throated evidentiary hearing, that judge in that case. There were witnesses, both from the prosecution and from the defense. Mark Meadows himself testified, as I recall. So that was a full hearing that really helped, certainly shape the course of that case. And this is something that anything else, as you say, I mean, the court granted broad immunity to Trump and to future presidents with this decision, but they effectively granted immunity to Trump from having having a trial before the election. So that's what can happen. That's what needs to happen. And it's just a question. Jack Smith at times has been conservative in the way that he is charged and in his approach to the case, but he can, and as we discussed last week, I think should go in there and call, he should call Mark Meadows. He should call, the former vice president. He should call, some of these cooperating witnesses, because now that's his new mandate, and that's Judge Chutkan's mandate, to figure out the parameters of what is and what is not immunized, and that's his way to do it, and that's the way that the American people can get a little window into the proof in advance. Look, generally, it's not great for the government to have to preview their evidence. It gives the defense several bites at the apple so that they can fine tune their defense in advance of trial. But here, there is no other option. So it really is just a question of how Smith wants to approach it, and how fulsome of a factual record he wants to develop. It'll be really interesting to see. And that could happen very quickly. It should happen very quickly.
Yes.
And by the way, Karen, just one last thing. I mean, we've talked about this, but Trump's legal strategy effectively has just been delay. And here I'm not sure he's going to be able to do that. He's will no doubt push back on a factual hearing, but I don't know. Maybe there are some legal maneuvers where he can try and get more time, but probably not. And I'm sure Smith, look, this trial was supposed to happen. What was it, back in March? Am I mixing up cases? So they were ready to go, I'm sure, and they have their proof locked in. So they should have witnesses lined up to testify. But we'll see. I have no doubt, next week, as early as next week, we'll see what Judge Chutkan is going to do, and what kind of schedule she's going to order for the next phase.
So before we move on to how is this going to apply to his other cases, including his recent 34-count conviction, I just want to summarize this for people, because this is really confusing, and essentially, through repetition, hopefully people will ultimately understand and get this. But the way you look at it is and what Judge Chutkan will have to do is look at the conduct and try to determine what type of conduct it is. And there's two types of conduct: official conduct and unofficial conduct. And if she determines that it's unofficial, then you can prosecute. So, for example, if she talks about that he was acting as candidate Trump when he did these things, they would be unofficial. Or, for example, things like the false elector scheme, et cetera. That I think is the piece of this that is possibly most protected. And then they look at the official conduct piece, and there's two types of official conduct. One where you get absolute immunity, and one where you get presumptive immunity. And essentially, if it's absolute immunity, you cannot prosecute it and you can't use it as evidence. If it's presumptive immunity, then they can rebut that. The prosecution has to rebut it. If after presenting evidence that tends to rebut it, that turns out that yes, he's immune, then you can't use it to prosecute or as evidence. If not, then yes, you can prosecute it. So it'll be very interesting. She's going to have to apply this test on official conduct where there's presumptive immunity, and she'll have to also make a determination of what things have absolute immunity, what things are presumptive immunity, et cetera. So that's where she'll be. That's what she's going to be doing at this hearing. And as you said, it's going to happen sooner rather than later. I want to talk about how this applies to all the other cases. But first, Danya, I'm thrilled. We have our first pro-democracy sponsor, and so we're going to take a really quick ad break for them. Let's face it, after a night having too many drinks, I don't bounce back the way I used to, for sure. So I either have to make a choice. I can either have fun with my friends or have a good next day. That is until I found Z-Biotics. This is a probiotic invented by PhD scientists to tackle rough mornings after drinking. I don't want to look puffy. I'm on TV all the time, or I'm doing a podcast. There's no reason to have that puffy feeling or those puffy eyes. So here's how it works. When you drink alcohol, it gets converted into a toxic byproduct in the gut. And this byproduct is not dehydration. That's not the only thing that's to blame for your rough next day. Pre-alcohol produces an enzyme to break this byproduct down. And so this is a proactive solution that wards off feeling miserable the next day instead of a reactive approach like drinking electrolytes or eating greasy food, also something I don't like to do anymore. So every time I have Z-Biotics before I drink, I notice a difference the next day. Even after a night out, I can confidently plan on being able to appear on television without worry. So admittedly, I was a little skeptical at first, but then when I was hanging out with a friend and having a couple glasses of wine, I gave it a shot. But now that I've tried it a few times, I know it works. And so I absolutely love Z-Biotics. And it's something that I will use if I'm going out to dinner, having a couple glasses of wine. So depends on whether you're on vacation, or shouldn't depend on whether you're on vacation, going to a wedding, birthday party, reunion, dinner, like me, anything. Get the most out of your evenings out and join the movement of people like me who are choosing Z-Biotics for smoother mornings and unstoppable success. So enhance your mornings with Z-Biotics. Go to zbiotics.com/MissTrial to get 15% off your first order when you use MissTrial at checkout. That's with 2 S's, by the way, MISS trial, no space. Z-Biotics is backed with a 100% money back guarantee. If you're not satisfied for any reason, they'll just refund your money, no questions asked. So remember to head to zbiotics.com/MISSTRIAL and use the code MissTrial at checkout for 15% off. Thank you so much, Z-Biotics, for sponsoring this episode. Okay, now we're back and we're here. So thrilled that we're starting to get sponsors and that MissTrial is off to such a strong start. And we're so thrilled with all the people who are joining us and who come and watch this great new show. Normally it's 3 of us, but rather than waiting until all 3 of us are always available, we're just going to hit these things as they come up so that we can get as much information as possible out to people and hopefully keep our followers and listeners as informed as possible. But Danya, let's talk about how this new Supreme Court test is going to apply to Donald Trump's other cases, right? We have the Mar-a-Lago documents case, we have the Georgia case, and we also have the conviction, the recent conviction at the Manhattan DA's office. What order should we talk about them in? I kind of want to end with the Manhattan DA's office because I feel like that one.
That's where all this starts. It's so juicy and it's breaking news. And exactly. It's obviously the one that, the only one that has been tried so far. And so there's the greatest sense of peril because the other ones, the proof they present, of course, and even the allegations that are in front of the jury can be shaped by this opinion. The other one is already, done and tried and convicted. And so the government just has to live with the case that it put on. And not shockingly, so do you mind? I just flipped it. But things are coming in as we're talking. We are seeing filings and the judge's scheduling order. So just to set the table here a little bit, I don't know how long, it was hours, maybe it was the following day, but I think it was the same day as the Supreme Court issued its ruling in the Trump case. Some of Trump's lawyers who tried the case in Manhattan sent in a letter to Justice Merchan there saying, wait a minute, this whole case needs to get thrown out now because of this immunity decision. And the Manhattan District Attorney weighed in and said, yeah, this needs to be briefed. They asked for a 2-week adjournment, or they agreed to a 2-week adjournment to do that. And then just as we were getting on the pod, we heard from Justice Merchan that he is granting the scheduling order. He will push the briefing out until July 24th, when the government will respond to Trump's arguments and motion. And then he said that sentencing will now occur on September 18th, I believe. I'm sorry. September 18th. And with this kind of ominous language, I'll just read it, that the matter is adjourned to September 18th for an imposition of sentence if such is still necessary or other proceedings. I think that's just normal hedging language, but my heart sank just a little bit, and I threw up a little in my mouth when I saw it. But I think, look, he's holding out any possibility. He doesn't, as always with this judge, he doesn't prejudge. He looks at all the arguments, all the facts, all the evidence, all the law, and he calls it as he sees it. So that's what he's going to do in this case. But we have a preview of Trump's arguments. Nothing surprising. Do you want to talk about that, Karen?
Good. You talk. Yeah.
Yeah. Look, they're saying exactly because we just got it, and it's in my it's in my text messages. The print is too small, but they are arguing that this Supreme Court decision essentially should require the court to throw out the jury verdict, because there had been a pretrial motion where the defense argued that they argued presidential immunity. They argued what they have, in the case that was just decided by the Supreme Court. Justice Merchan said no, he wasn't buying it, and he threw out that motion. And now what they are pointing to, what the defense is pointing to in particular, is certain testimony and evidence that came in that they are arguing relates to the former president's official acts, including conversations he had in the Oval Office. There was a testimony from his secretary. There was testimony from Hope Hicks, who worked for him in an official capacity. And so what they're going to argue is, you can't put the genie back in the bottle. You can't unscramble the eggs, that this was prejudicial, and then that this was improperly admitted evidence, given it seems they're relying in particular on that portion of the Supreme Court's decision that talked about the restriction or limitation of evidence that could even come in front of a jury. And the Supreme Court, as we talked about before the break, Supreme Court said that evidence of official acts can't even come in at all to prove up unofficial acts or personal acts. And so that's the argument here, is that the jury was tainted with this kind of testimony and evidence, and the whole thing needs to be thrown out. And, whether it's tried again, or whether if the court says you can't try this case without that evidence, that seems a bridge way, way too far. But it probably won't stop them from arguing that. Do you agree, Karen?
Yeah, completely. I mean, I have so many questions. For example, how can, this is, I'm just completely changing the subject, but I'm just, as you say all this, so many things are coming in my head. How could a president be impeached for a high crime and misdemeanor if there's no such thing as a crime? Because he's acting in his official. Do you see what I'm saying? How circular this is? Like, it makes no sense. I mean, the fact that you can be impeached for a high crime and misdemeanor.
Yeah, no, it's a great point. I mean, Justice Sotomayor in her dissent said that this decision creates a law-free zone around the president. So that's right. How could he be impeached for a crime? I guess it's a separate.
You're immune.
One is a matter of law, and the other is but it's hard. Look, I think since the founding of this country, as Justice Sotomayor said, it's never been anyone's understanding that the president could commit a crime and be totally shielded from it. I mean, certainly, as we talked about, Nixon didn't think that. He was pardoned because there was some concern by Ford that and others that he would be criminally prosecuted because everyone thought that he could. And Mitch McConnell, when and others, right after January 6th, said this, you know, the Senate is not the proper forum for this trial. If he's going to be prosecuted criminally, let that happen. It's not until, as you say, this made up decision, you know, where now it turns out there is no such thing as a crime when it's committed by a president, effectively.
What's also weird about it is he can order his underlings to do certain things and they can still be prosecuted.
Exactly. Everyone could be prosecuted. If he orders,
Clark,
you know,
still fair game, for example.
Yep.
I mean,
if he ordered the Secretary of Defense to, you know, take out his political rival, the Secretary of Defense could certainly be prosecuted, but he could not for ordering that hit.
But he could not be, and then he could pardon that person, right, for doing it. I mean, just think about it. Like, I just, and I don't mean to be so kind of, but this decision, just when you think about all the ways how dangerous and bad it is, it's just shocking to me. But back to the Alvin Bragg case, because you just, as you're talking, my mind just keeps going like crazy because I just can't believe it. The sentencing was supposed to be July 11th. It is now postponed till September 18th. Before that, however, every motion practice is due to brief these issues. And so the decision on the motion practice is coming in early September. And we'll know the ruling ahead of time. And then, if necessary, this sentencing happens September 18th. So the motion practice that's happening is being done under the criminal procedure law 330.30, which is post-verdict motions. It's basically in between the time of a verdict and sentence. There's this window of time that you can make these 330.30 motions, which are post-judgment motions, anything you want to argue. Here, they're going to argue that he's immune because of this decision. I talked to some people this morning who were saying, yes, but the time passed. He was supposed to file 330 motions a month ago. That time has passed. But how can you file a motion for something that you didn't know existed yet? So I don't think that carries any water. The judge clearly allowing it, which is why he set a motion schedule here for people to argue it. And I agree with you. The thing that is going to be most, I don't want to say in peril, but, you know, an issue is evidence. It's going to be evidence like tweets that came in, right? Tweets that were, because one of the things the Supreme Court specifically talks about is one of the core functions of the presidency is to speak to the American public. And so therefore, social media, press releases, press briefing, whatever, just speaking publicly, those words can't be used as evidence against him at a criminal trial. And we know that a lot of this case also brought in his own words while he was president, right? A lot of the tweets were significant. So what's interesting about this case is, unlike the Washington, D.C. case, Tanya Chutkan needs to hold an evidentiary hearing because there has been no presentation of evidence. In this particular case, there has been a fact finding. There was a trial and the witnesses testified under oath and were cross-examined. So I don't think he needs a hearing. I think he can decide this on the papers. What do you think about that?
I totally agree. He can make findings of law. As a matter of law, were, you know, each of the tweets that the government published to the jury, were those official acts or were they personal? I mean, they certainly, you know, there was evidence of tweets during Trump's presidency, and we should talk about this. Most of the criminal conduct itself was all, by definition, right, it was election fraud, so it was pre-election conduct. So most of the conduct itself is not going to be in question, but as we've said, the evidence was, and there were tweets that from, you know, former President Trump's account, which talks about, you know, Michael Cohen being a liar or being a scumbag, or Stormy Daniels or the NDA. You know, some of that evidence came in, and Justice Merchan will have to make a ruling as a matter of law. Were those official acts or were they outside the purview of his presidential duties? It seems to me that should be a pretty easy one. He's talking about, you know, the allegation that he had sex with a porn star many years before the presidency. Seems pretty personal, but there was that language that you pointed out in the Supreme Court decision that at least requires a fact finding. But some of it is clearly going to. It seems to me the judge should find was admissible and was properly admitted, including the filings, the financial filings that were introduced that are matters of public record. The Supreme Court specifically said that the prosecutor can point to the public record. So it's going to be, I think it's going to come down to some of those tweets, which again, I think is relatively easy. And then some of the witness testimony, including about, campaign activity, which should be unofficial conduct, right? It should be candidate conduct, but, the conduct about the testimony about how, checks arrived or were sent, I guess that will be in contest and the judge will have to make a legal determination. To me, again, it seems relatively straightforward since this was so clearly, of all of the cases that are out there and that have been charged, this one, was pretty exclusively pre-presidential term conduct. Yes, checks were sent out, but that was in furtherance of the that conduct. So I like the DA's chances on this, but I'm sure they don't like having to have this played out and the sentencing proceeding pushed out by more than 2 months.
I suspect Judge Merchan, in his analysis, will do a harmless error analysis. So because it's certain pieces of evidence that may have come in, he'll probably rule one way or another, but he'll say even if it is, it'll be harmless. Even if this did come in and should not have its harmless error because the evidence was so overwhelming, otherwise this was just extra kind of thing. So I think he'll do a harmless error analysis if there was any evidence, or even if there wasn't. If he'll hedge in case he gets it wrong. And this is, the other thing I think he will do is, I think this further solidifies my thinking that he will stay any sentence pending appeal. In other words, if he sentences him, I imagine the sentencing will be that he says, look, if I were to treat you like any other defendant, there's no way I can't give you prison time or substantial jail time because the nature and gravity of the conduct here as compared to others that have received jail or prison. This is one of the worst falsification of business records in the history of that statute, plus his conduct before the trial, the baseball bat to Alvin Bragg's head, the threats to everyone under the sun, just his whole conduct before the trial and then during the trial with being held in contempt 10 different times, and his conduct after the trial. I mean, he shows no remorse whatsoever. He still blames everybody and says he didn't do it and all that kind of stuff. The fact that he went after jurors, the whole thing is just beyond imaginable. And I think the judge is going to have no choice but to say, I have to treat you like everybody else. And I'm going to sentence you to jail or prison. And, but he will stay, which means press pause on making him go in until the appeal. And I think because of this issue, I think it's even more so likely that he will stay at pending appeal because this is such a significant, serious issue. And it'll also have the benefit of letting the American people make a choice one way or another. Because if he is president, there's no way he would serve any time anyway. And it is what it is. So that's where I see this happening. Do you agree, disagree?
Fully agree. It's another chit. This judge has actually said explicitly that he was reluctant to put this defendant in prison. And I think this is just another reason why he's going to be even more reluctant. So I think, yes, any sentence. Look, I think you and I have a mild disagreement about whether or not there's going to be any sentence of a jail term. But I certainly agree. If there is something, it will be stayed, not just pending appeal, but as you say, if this candidate becomes president, it will be stayed certainly during the term of his presidency, which may go on forever because he'll now be constitutionally allowed to give himself another term. I mean, there's nothing he can't do to stay in office that he would be prosecuted for. So maybe he'll just elect to stick around for as long as long as he lives, and then he'll never go to jail.
Interestingly, he withdrew or waived, I can't remember which, his presidential immunity claim during the removal proceedings in front of Judge Hellerstein. If you remember, he tried to remove, this is a state court prosecution, and he tried to quote unquote remove it to federal court, which is and you have to make a certain showing in order to do so. And there he withdrew, I think that was a supremacy clause case, and he withdrew presidential immunity. And it's interesting to me that there could be a waiver argument, although I'm just not sure. But that's another question that I think Judge Merchan is going to have to grapple with.
Did that come up in the previous briefing on the pretrial motions? I just don't remember, because this is all such breaking news.
So no, it did come up, and Judge he tried to bring it up, and they said you waived that, and so that was kind of long. The time passed, but now that you have a new ruling, I wonder how that impacts it. That's the question that I just don't know the answer to, but I know Judge Merchan will address that for sure as well.
Yeah. Well, so we'll look forward to the briefing later this month.
I know. Let's talk a little bit about how it impacts the other cases too, Mar-a-Lago and Georgia. I mean, Georgia is essentially the same as Jack Smith's case, except it is heavily weighted on the state of Georgia, which is more in line with the candidate Trump stuff, as the unofficial version instead of official. So I think that if that case ever goes anywhere, which I don't think it's ever going anywhere, that case seems dead in the water given all the things there. But I think it has a significant impact on that case.
Yeah, I agree with you. I mean, in the exact same way, although, yes, there are more allegations that with respect to his conversations and conduct, with Georgia officials, not federal officials. And he was very clear, just unbelievably explicit, right? And looking to find, 11,000, what was it, 780 bullets, whatever it was. It's hard. I'm trying to look at this as though if I were, a neutral judge, what would I think about whether that relates to an official act or whether to a candidate's, plea for, it certainly seems to fall into the second bucket, but there will have to be a factual analysis there too. So it does seem to me like the Mar-a-Lago case is going to be the one, both because the issues are trickier and less clear, and I think because we're in front of Judge Aileen Cannon, who has shown herself remarkably open to some what most legal scholars would consider to be pretty frivolous arguments. I think that's going to be a squeaker and one to watch.
It's unbelievable to me how he gets himself into these positions where he just skates and doesn't be held. Like, how does he pull the luck of the draw and get Judge Aileen Cannon? How does he? I mean, there's so many areas where it's so frustrating and head scratching. But once again, in the Manhattan DA's office, people were saying, why this case? Why is this going first? This case shouldn't have happened. And I couldn't be more proud of my old office for being the one case that actually might be the only case ever. So it's just fascinating to me how we are where we are. But Danya,
it does seem crazy though, right? Just when you think, okay, I mean, we're supposed to have, see a sentencing in 9 days. And then at the last minute, literally the last minute, because the Supreme Court extended its term in order to give him even more time. Now, I don't know if that was the reason, but that's what they did do. And, now it's another 2+ months. It just always seems like there's something in that. The delay tactics do generally break in his direction. So now we've got, we'll wait another 2 months and see. But hopefully in the meantime, just to circle back to kind of where we started. In the meantime, we'll see what happens in front of Judge Chutkan if we get our factual hearing, and if we get to see some of these witnesses and some of the proof in front of not a jury but this judge.
You know how things in the law have a name? They all have names, like, oh, we're going to have a Fisher hearing, or we're going to have a, whatever. It takes on a name. I'm going to call this the Danya hearing. So she's going to
we'll see if that sticks. Let's see if that takes fire.
Well, it just was such a smart way to think about it. Anyway, I think we've reached the end of another episode of MissTrial. There's no one I'd rather pick their brain and talk these issues through than you, Danya. And so you have such an incredible insight. So I just
love it.
All right.
We'll do it again next week unless something crazy breaks between now and then.
Exactly. Well, thanks everyone for joining us and tuning in, and stay tuned for the next episode of MissTrial.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.